So, welcome. All right, well, we're going to get cracking here. Welcome. I'm attorney Peter Harbach from Hooper Law Office, and today's topic is going to be taxable estates, and just walking through a general overview, the real basics of what estate tax actually looks like, and then a couple, and I mean a couple, of the many different options that people have in terms of addressing estate taxes if it's applicable to their situation. A couple little housekeeping things. Everybody who's registered will receive some materials from us via email. I've got a history of the estate tax here. And then there's also links to our website, because some of the techniques and some things that we're not going to have time to get through today are explained in greater detail on our website. We've gotten good feedback that there's a lot of good material on there. So if you peruse our website, which is www.hooperlawoffice.com, hopefully you find some good information on there. I also want everybody to know that our next session is going to be September 16th. So not next week. We're taking a week off from this. And next week's session is going to be on planning for like the recreational property that you might have, the family cabin, the cottage, the hunting land, whatever it might be, because there's a lot of things that different considerations for that type of property in your estate plan. All right, well, we'll get into this stuff. As always, if you've registered and have questions, please just type them in your Zoom box, and I'll do my best to address everything towards the end of the class today. Okay, so the estate tax, probably the least understood tax in all of the taxes. So estate taxes is a completely separate tax system than, for instance, capital gains taxes, income taxes, sales taxes. Those are the things that pretty regularly apply to almost everybody. And so most people have at least like a general working knowledge of these things. But the estate tax is very misunderstood and doesn't get nearly as much sort of publicity and discussion that the other systems do. So again, estate tax, wholly separate system. And it has changed so very much over the years that unfortunately, a lot of the planning that might have been really good and applicable, say 20 years ago, is potentially detrimental now. And so that's some of the stuff I'm going to highlight, because some of the viewers here are probably going to realize that they don't really have an estate tax issue presently, but maybe didn't do the best planning for today's environment because they did it 10, 15, 20 years ago. And now they're maybe going to be paying more taxes than they needed to. So basically, the estate tax is this excise tax. It's a tax on the estate after somebody passes away, and it values everything that the person owns. So this is their land, their house, their bank accounts, their IRAs, their life insurance, many different types of trusts that would be considered includable in their estate for tax purposes. All of those things basically get added up at death, and then somebody's remaining exemption amount gets applied, kind of like you apply a coupon. So it's like a really big deductible, essentially. And then it's determined, okay, if the deductible didn't essentially take care of the entire size of the estate, the leftovers are subject to an estate tax. Now, these days, that sort of coupon or deductible is gigantic. I mean, we're in the neighborhood of $11.58 million per person. So that is gigantic, which means for many of you who might be watching, you just say, well, I don't have $11.5 million bucks, so it doesn't apply to me. Well, there's still a bunch of things that you're going to want to consider in this. It has not always been as large as it is. For instance, we've given a sheet with the last 25 years of the estate tax on here, and what the exemption amounts are, and then what the top tax rate is. I mean, these days we've got this, $11.58 million coupon, but you got a 40% tax for any of the overage. 25 years ago, you had a $600,000 coupon and a 55% tax. Well, $600,000 and $11.5 million are worlds apart in terms of value there. So many of you may have had an estate tax at the time that you've done your planning, because just to rattle off a few amounts here, in the year 1999, there was a $650,000 exemption amount. In the year 2007, $2 million exemption amount. In 2012, a $5.12 million amount. And these days, like I said, over 11 million. Well, so it's been kind of all over the place. It's generally been going up, but some things are very temporary in this. So, for example, we were at about $5.5 million back in 2017, and that's per person. So a married couple can effectively pass twice as much because each of them has this coupon. Well, in 2017, there's this thing that's often referred to as sort of the Trump tax cuts. And that effectively doubled the exemption amount that's applicable from the roughly $5.5 million to the up over $11 million exemption. Well, what a lot of people don't realize is the Trump tax cuts are not permanent. They revert back to the old numbers come 2026. The only permanent part of the Trump tax cuts were for corporations. All of the individual tax cuts for income taxes and estate taxes, all of that stuff for people is temporary until 2026. So if you're thinking, boy, I have $10 million, I don't have, over $11 million, so I don't care about the estate tax. Well, depends on the year you die. And it always depends on the year you die, but now we have a timetable where we know, okay, if I die now, I've got a big enough coupon. If I die 6-7 years from now, I don't have a big enough coupon because the coupon will have been cut in half. Now, any of these laws are always subject to change. If Congress agrees on something, on those rare occasions, they can change any of these kind of tax laws on us. So I can only tell you how it works right now and what it's scheduled to be in the future. But there's no guarantees in these things. So law can absolutely change, but right now we know that the exemption amount will get cut in half in 2026. So one of the reasons it's important to understand that the tax was the coupon amount was pretty small back, say 20 years ago, and it's very large right now. It doesn't mean that it's not applicable to people. Again, it doesn't matter what today's coupon is. It matters what the coupon ends up being the year that you die, because that's when the estate tax is applicable to you. And so Congress has this tendency to sort of switch around what pools of money they want to raise revenue out of. And sometimes it's sort of popular to be taxing estates, and presently it's not very popular, so there's a really big coupon. But a lot of practitioners are sort of guessing that the estate tax might come roaring back, in part to pay for like the coronavirus relief bills. There's been several $1 trillion spent recently, and some people are betting that, well, the money's going to at some point have to come from somewhere. Maybe it's going to be the estate tax. Again, nobody knows that for certain, but there are some fairly well-informed practitioners who are putting their money on that. So if you did your estate tax planning, and maybe you have a modest estate, maybe it's maybe $1 million estate, but you did your planning back in the late 90s, and maybe at that time you were talking to an estate planner who really knew what they were talking about, and said, boy, we've got to do some planning or else you might be subject to maybe a 55% tax because you, married couple, are over the current exemption amounts for the 90s, which is like 650,000. So what you might have built into your estate plan is a very popular tool, which is, okay, we do a joint trust, and when one of us passes away, the survivor keeps some, and some goes into something that's often called a family trust. There's a lot of different terms for these family trusts. They can be called a bypass credit shelter trust, or sometimes they're just called the B trust in an A and B trust plan. What it basically means is, so money is going to go into this family trust, and it's going to use the coupon of the person who passed away. We're going to use their existing exemption amount to put money into that family trust. And that family trust is going to support the spouse during the spouse's lifetime so that their needs are met. But this family trust is not includable in the estate of that surviving spouse when they then pass away. So no estate tax gets applied to it because it already got the coupon from the first spouse who died applied to it. So that was excellent planning for dealing with estate taxes. And it still is for people who have large enough estates for that tool to be applicable to them. The reason that's very important to understand, if it's still built into your estate plan now, but maybe you have a smaller estate than these large coupons we're talking about, well then, you're doing estate tax planning when you don't need it. But what you're giving up in that family trust now, that isn't fixing an estate tax issue because you don't have one, but now on that family trust, you are very likely giving up in a basis adjustment on death. One of the good things for people to have assets in their estate when they die is if the value of those assets have gone up over the years, it's good to have things in your estate if they're subject to capital gains taxes. And capital gains taxes in a nutshell would be, hey, I bought this stock for $50 and now it's worth $70. So I have $20 of capital gain built into there. So then when I sell it, or if I gift it and the recipient then sells it, they're going to pay tax on the difference between the $50 and the $70. That's the amount subject to capital gains taxes. Well, if I had this stock in my estate and I die, then the new basis for the recipients of that stock is going to be that $70 mark. So there's this basis adjustment up to fair market value on the date of my death if the thing is part of my estate. Well, the reason that matters so much is with these family trusts, generally speaking, they're drafted so that these assets in the family trust are not part of the estate because we don't want an estate tax to apply. And we wouldn't want an estate tax to apply if at the time you were setting up the planning, it looked like you might have had a taxable estate because the coupon amount that year would have indicated, hey, if you died now, or if you die in the foreseeable future, it looks like you might have an estate tax. But again, nobody could have predicted in the 90s, 2000s, that in 2020, we were going to have a over $11.5 million coupon. So you might have been dealing with estate tax planning that you no longer need, but now you have assets that are going to be in a family trust that aren't going to get a basis adjustment. So now your beneficiaries are going to pay an unnecessary capital gains tax. And so that's one of the key points I want people to understand, where if you did, this is a perfect example of if you did your just basic estate plan in prior years, This is the type of thing why you need to look at it again and potentially adjust things. Now, there can be other reasons for funding one of these family trusts. You know, they're very popular in, for instance, second marriage situations and blended families. But again, in most circumstances, there's not going to be a basis adjustment on that family trust. So you're fixing an estate tax issue that you do not have in order to, and you're giving up, excuse me, a capital gains tax adjustment and forcing an unnecessary payment down of taxes to your beneficiaries. So it's one of those things that really should get looked at. Older planning can wear out and not create ideal results with these changes in the law. So also, in addition, and this is a more recent thing from about 2012 or 2013, there is this new concept called portability, which is if you have a taxable estate or you're near the thresholds where you're not certain, but it's possible you could have a taxable estate, it's now possible to file an estate tax return in order to claim, if your spouse passes away, whatever their unused coupon is for estate taxes, you can claim that and bring it over and add it to your own. So it's called the deceased spouse's unused exemption amount. And how you file for that with portability is after the spouse dies, you have to file a timely 706, which is the estate tax return, and you claim their leftover coupon over to the surviving spouse. So that is an alternative to doing family trust and surviving spouse trust type planning. One of the issues is the assets could go up in value over time during the lifetime of the surviving spouse, but the coupon doesn't go up in value. So sometimes filing for portability sounds easy, but it might not end up being the best choice. These are very intricate decisions that need to be made between you and the estate planning attorney that you're working with. Everybody should also know about the sort of lifetime gifts and annual gifts that you can give. Now, I talked about this lifetime exclusion amount that's over 11.5 million bucks per person, but you also have an annual amount that you can give away to every individual that you've ever met every single year without having to do any reporting or telling the IRS about it at all. And so it's presently $15,000 per year. So how that works is you could give up to $15,000 of cash or gifts or whatever to anybody that you want or everybody that you want. And you don't have to tell the IRS anything. But if you go over that amount, you have to file a gift tax return and tell the IRS about what it was that you gave. And they're going to take out the overage from your lifetime coupon. So it's referred to as this unified credit. You can give stuff away during your lifetime, but if you go over these annual limits, it comes off your lifetime coupon, and your lifetime coupon could get all used up where you don't have any coupon left to apply to your estate when you die. So that's how it's unified. It's both lifetime and death. And this is how they keep like Bill Gates from giving away $80 billion so that he dies a pauper and has no estate tax. Those lifetime gifts would have eaten up his unified credit because it's a credit for both gifts and estates. So the reason this $15,000 is important is, one, it's a way to transfer some wealth during your lifetime. You know, you got 2 kids and 4 grandkids. Well, then that's 6 times $15,000 that you're able to give away every single year to them. You know, there's no reporting, there's no tax applied for at least estate and gift taxes. And that's a way to kind of reduce the estate. If you're married, you can double those annual exclusion amounts because you can do this thing called gift splitting, which is, hey, me and my spouse, We can give 30 grand together to all of these different people. So it's a way to kind of reduce the estate. For those of you who might be concerned with long-term care expenses, you probably don't have a taxable estate if you're real worried about long-term care expenses, because people who have more than $11 million aren't too worried about affording a $10,000 a month bill at a nursing home. But if you have maybe a more modest estate, you should know that these gift tax annual exclusion amounts are not a safe harbor for nursing home planning, meaning you can't give 15 grand away to all of your kids and then go into a nursing home and say, well, I don't have enough money to pay for it, and apply for Medicaid and get a Medicaid assistance, because they have a 5-year look back period on this kind of stuff. And so if you gave away all of that money thinking, oh, well, it's my annual exclusion amount, it's not a way that you're going to have penalties for it. It's not a safe harbor. This IRS rule is totally different than nursing home rules. 2 different programs, 2 different intents. They do not mirror one another or play nice together. So no safe harbor there under this annual exclusion if you're concerned about nursing home costs. So again, we've got family trust planning, which can be very good for people who have taxable estates. But if you do not have a taxable estate and you have old estate planning, well, then family trust planning might actually be detrimental, because it could be causing greater capital gains taxes at your death than are necessary, while it's not fixing an estate tax. There's also portability, which we talked about, which is essentially, hey, I can file for my spouse's unused coupon amount, so that it shifts over to me, so that when I pass away, we have a greater amount of exemption that we can apply to the overall estate. There's also proactive planning that people can be doing around estates, and should be doing if they have taxable estates, or at least looking very carefully at considering. And a lot of this next group of planning has to do with establishing trusts. Trusts are very popular estate tax planning tools, and there's lots and lots of different types of trusts. Some are used for protecting assets from long-term care expenses. Some are used for avoiding probate. Some are includable in somebody's estate when they die. Some are excluded from somebody's estate when they die. Some are taxed to a person during their lifetime, whether they're revocable or irrevocable. Irrevocable meaning can't just change it however I want. Revocable basically meaning I can just change it. And then there are others that are excluded from somebody's, or excuse me, included from somebody's estate. And that would generally be any revocable trust and some irrevocable trusts. So there are tons and tons of types of trusts out there. I really only want to briefly mention a couple of the most popular estate tax planning ones, one of which is called an irrevocable life insurance trust, which is essentially you get yourself a policy for life insurance, and the policy's value is generally going to be a lot less right when you first get it than when you pass away, because that's when it sort of explodes in value because it receives all of those funds. Well, a lot of people choose to transfer a life insurance policy into an irrevocable trust during their lifetime, because the transfer of the policy in most instances is going to be a lot less valuable when they're doing a lifetime transfer of it than before they die. So they have to use only maybe a little bit of their big coupon. In some instances, it might even be just covered by the annual exclusions. So they transfer the policy to a trust, and then they have beneficiaries of the trust. And the beneficiaries are often kids and grandkids and the loved ones that you're trying to support. And what's often done then is they're transferring funds on an annual basis to that trust in order to pay the premiums, so that when the person passes away, the trust owns the policy, and there's not going to be any kind of income tax on the receipt of a life insurance proceeds. So that's great for the beneficiaries who are receiving it. And it's outside of the estate for estate tax purposes, so that, if they had $1 million policy that they put in there, that whole $1 million is probably transferring essentially tax-free and is not part of the estate tax that's applicable to the person. So just one, there's many details that we just don't have time to get into, but that's in essence about how many ILITs or irrevocable life insurance trusts work. There are various ways to set these up, as grantor and non-grantor trusts, and how you have the things taxed and how you actually pay the premiums. But that is just one common example of how that might work. Another thing is a spousal limited access trust. And essentially, one spouse would set up a trust, potentially for the benefit of that other spouse, and transfer assets in there that they're probably intending to use up some of their lifetime coupon in putting assets in there, but making sure that those assets then and the growth of those assets are not includable in the surviving spouse's estate when they then pass away. And so that's a way where there's still some direct use of the money there by that other spouse. So it can benefit them as a whole, but it's getting the growth out of the estate, which in enough years, that can be a very powerful estate planning technique. And a secondary thing is there's some ability to provide some amount of asset protection in certain circumstances by using that technique as well. So these are just a few basic things on estate and gift taxes as just a general overview. I could go on for another 6 hours about all those different things, but hopefully, the big takeaways here are, if you have time and assets, you don't want to neglect doing estate planning, because time is your friend when you're doing estate tax planning. You want to leverage as much time as possible to get the best results. And so if you scurry to try and do deathbed planning, you're not going to be able to save as much if you have a large estate from estate taxes. It's something you want to do proactively. If you did estate tax planning in previous years, you may no longer presently have a taxable estate, and that planning might be detrimental to you. So it's a great reason to review your estate plan sooner rather than later. I've never had a client in my entire life, and I probably never will, tell me, hey, I want to pay more in taxes than is necessary. Well, if you have a family trust and no estate tax, but you're going to pay capital gains taxes, you're paying more taxes than are necessary. So it's a great reason to do a review of your estate plan there. And if you're concerned about long-term care expenses, know that there's no safe haven for those gifts because of the annual exclusion. Those are two totally different programs. One's the IRS and one's Medicaid. So hopefully, you learned something here that you can kind of take away and use. The point of these obviously is informational, to try and get a good sense of how stuff works out there. But it's not just enough to listen to it. Do something with this information now to help your family. I mean, that's the goal here. And so if anybody wants to follow up on anything that we talked about, if this stuff seems applicable to you, there are many other estate tax planning techniques that we just don't have time to cover. But we do free consultations to potential clients to sit down and go through what is your individual circumstances and what we might recommend in order to try and meet your needs. So feel free to reach out to us if that'd be helpful to you. Otherwise, again, next week we're not having a class, but the following week on September 16th, we're doing the family cottage planning. Also, there's an event coming up on Tuesday, September 22nd. And it's we're calling it Drive into Healthy Aging. We're sponsoring this with a group called Care Patrol. And basically, it is just, we're at Field of Scenes in Freedom, and we've paid for a little comedy segment. And then there's going to be a free drive-in movie. So we're trying to do something to get people the heck out of their houses during this pandemic, and kind of socialize, but in a very safe environment. And so we thought a drive-in movie was kind of perfect for that. So Hooper Law Office and Care Patrol is sponsoring this event. Again, it's Tuesday, September 22nd. Gates are opening at 6:30. The comedian starts at 7:30, and then the movie to immediately follow that. So thank you, everybody, for your time. If there's anything you need to follow up, please contact our office. Otherwise, I hope to see you on the 16th. If not on the 16th, on the 22nd. Take care.